Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hello, I'm Natalia Angelini.
And I'm Haley Daniel.
Welcome to Hull on Estates. You're listening to episode number 687. Today we're going to be talking about the question of retracting a renunciation. It's something that doesn't come up too often in our area of practice, but there were a couple of cases of late that Ian Hull had belonged on that Haley and I thought would be good decisions to chat about further on a podcast. So welcome, Haley. It's our first time podcasting together.
Thank you. I'm happy to be here.
Well, good. So let's dive into the first case, which is the Hunt and Hunt decision. This was a Saskatchewan decision, right?
Yeah.
Why don't you tell us a little bit about it?
Yeah, of course. So it was decided in 2023, so it's quite recent. And in this case, the deceased will appointed both of her children to be executors of the estate. But at the time, her daughter renounced the appointment, allowing the brother to be continued as estate trustee. This occurred before probate was granted. After a little bit of time of the daughter seeing how her brother was handling the estate, she was not happy with it, and she then applied to the court to retract her renunciation in hopes of becoming an executor. The court ended up allowing this application since probate wasn't yet granted, so this seemed to be a pivotal point in this case, and they were fine with this, even though there were some warning signs that this could cause some animosity between the siblings if the renunciation was retracted.
Right. And it's interesting that, in the decision, and we'll have both decisions up on our webpage you could link to. But it's interesting that the court, noted that counsel didn't have any authorities, didn't refer the judge to any authorities, and that research on that only revealed a few cases. And what was gleaned from the case law was that, retracting a renunciation by an executor is only reluctantly permitted in exceptional circumstances. And, if it's being done for, for the person's benefit, but for no one else's real benefit, then the court's not going to allow that retraction. So leave is something that the court, I guess, seriously looks at. But in this case, if it's shown to be in the best interest of the estate, right, and those with an interest therein, the court would make such an order. And importantly, with probate not having been granted yet, I think in the Hunt and Hunt decision, it made it. I guess not a big hill for the sister to climb, right? And what about the other decision, Haley, the Sioux estate decision?
Yes, so that one is also a 2023 case. This one is from BC. So the facts are a little bit different, but there is that overlap of the renunciation issue. So in this case, the executor named in the deceased will renounce the appointment, but then reapplied to the court to be appointed administrator. Well, the applicant had claimed that the renunciation had been conditional on his sister being appointed administrator in their place. The judge at the time concluded that the renunciation had been final since the original document didn't indicate any sort of condition as the applicant had been claiming. The court then rejected the applicant's request to be appointed administrator in light of this fact, and that the applicant and the deceased were embroiled in several lawsuits when the deceased passed away. Means that if the applicant were to continue on as administrator, they would be representing both parties of litigation, which is obviously a big conflict of interest. So in this case, the retraction of the renunciation wasn't allowed. So it's in stark contrast to the Hunt decision.
Right. And I guess it sort of reminds us, right? Every case is so fact specific. And because of the various proceedings and the conflict that would create, the court ultimately decided, no, you're not going to be allowed to retract that. And they ended up appointing another relative that was more neutral or less controversy around that person being appointed as a state trustee. And, these cases serve as good reminders for us as practitioners. In my view, if we're advising a client who's considering renouncing, to really give it thorough consideration, because, you think about who else is appointed. Maybe there's a co-executor who is appointed and you don't know what the level of trust is there. Maybe the person renouncing also has a substantial stake in the estate. And, so they want to make sure whoever is left remaining or whoever is going to potentially be appointed, maybe there's no alternate, that there's an amount of uncertainty there, amount of a certain level of risk that the person's taking by not accepting control of that estate. And I guess you balance that against the very serious obligations one has as an executor.
Yes, I agree. I do look back in the blog, they mentioned McKee Estate, which is a 2003 BC case. And in that one, they were quoted saying, retraction of a renunciation by an executor is only reluctantly permitted by the court in very exceptional circumstances. Right. Which I think is interesting because although in this podcast we're talking about Hunt where it was allowed, it's important to keep in mind that these are rarer circumstances rather than it being the norm where a retraction is allowed.
Right. And like we said, each case on its own specific facts will likely, influence the outcome. But, if your client, if you happen to be acting for someone who changes their mind, it's good to perhaps have these cases to look at to help guide us in terms of, what recommendations we're making as to whether to pursue that or not, because you do need the court's leave to pursue. It's clear that a renunciation can be withdrawn, but, as Haley said, not the norm. So just an interesting point for us to think about.
Yeah, and I think it would be really interesting to see more Ontario cases as well on this point. As we noted, the ones discussed here were Saskatchewan and British Columbia. So I'd love to see what our Ontario courts have to say about this issue.
Yeah, there's really little case law on this, which is unfortunate, right? We'd like to have that guidance. We've got the out of province guidance, but it would be good to have an Ontario decision too, though I certainly, as we noted, this is something that it's not going to likely come up. So I don't know how soon we'll see this kind of case, but it would be helpful to have some local authority.
Yes, agreed.
So unless you have any other thoughts, Haley, I think that concludes our podcast. And yet, okay, great. Until next time, we want to thank you for listening. I'm Natalia Angelini.
And I'm Haley Daniels.
Should you have any questions, please email us at info@hullandhull.com or contact us through the contact page on our website. Thank you.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.